Good afternoon, everyone. Today I will be presenting the lawsuit of Naraindas, Sadhwani, and others. On behalf of my team, at first I would like to present general information about the lawsuit, as this lawsuit is pretty complicated and complex because a number of parties are involved in the lawsuit. Okay, I'd like to move on into facts about this lawsuit. I have a chart in front of this PowerPoint screen and hope this chart will help me to explain this lawsuit more clearly because as I mentioned that a number of parties are involved in this lawsuit. Okay, so the story began when the Bank of India sued against the Gobindram's family who had acted as guarantors for a credit line of 230 yen, which is approximately $2,300,000. Okay. The Gobindrams were residents of Hong Kong, and the bank was an Indian corporation, and its head office was in Bombay. The two other regional offices were in Osaka and Tokyo, and the manager of the Japanese subsidiary was Gobindram's brother. The Cochin Lands owned 60% of SJL, and the Gobindrams the remaining of 40%. So if you look at the chart on the left hand side down the bottom, Mr. G 40%, and on the right hand side down the bottom, Mr. K 60%. Okay. SJL had drawn bills from exchange that was supposed to have been paid by corporations in Sri Lanka and Nigeria that were run by other brothers of Mr. G and Mr. K. Okay, the problem literally started here when these bills have discovered to be dishonored, and the bank wanted payment from Mr. K, but he thought that the bank should pursue his guarantors, who were the Gobindrams. But the bank did not really care about because it has agreed that this family as guarantors. The bank finished pursuing them in front of their Hong Kong court. Okay, now this lawsuit is getting more complicated because there are a number of parties are involved in this lawsuit, and also the bank has different branches in different locations in different countries. So it's the issue of whether the Japanese law is the proper law of the contract of guarantee. Okay, so it's important for people to understand rule of law. According to this particular lawsuit, the general rule is that the court should apply the law of the state that has the closest and the most real connection to the dispute, considering that the expressed or inferred intention as to the proper law is absent. The Bank of India, the plaintiff, argues that either Indian or Hong Kong law should apply based on the inferred nature of the contract. The Gobindrams, who are the defendants, argue that Japanese law should be used for the guaranteed contract based on the closest and most real connection. As you can see now that the lawsuit is getting more complicated because it is confusing of which law and which law of which country should be legally applied to this lawsuit. Okay, we are now getting to the most important part of this lawsuit, as some of these factors are the place of economic performance must be regarded as Japan, and some considerations are place of relation, place of negotiation, place of injury, place of act, and the other factor is the form of guarantee has type references to yen, which is indicative of Japanese law being the common choice. And the last factor is the most influential guarantor, who is Mr. K, resides in Japan. Okay, therefore, the proper law of the contract of guarantee has to be Japanese law, and Japanese law already excuse the Gobindrams from liability. Okay, in conclusion, this lawsuit is very interesting because a number of people are involved in it, and also the bank has different branches in different locations in different countries. This is the reason why this particular lawsuit is very complicated and complex. So it is important to understand that which law should be applied according to which country that would be most related to the lawsuit. So according to this particular lawsuit, the final answer, according to the factors that they used to judge of which country would be related to this particular lawsuit, and the final answer was the Japanese law, which is the proper law of the contract of guarantee.